Hello and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. We are talking about advanced degree PERMs in this set of videos, and we've done some introductory videos on what's preliminarily needed. I'd like to just do a few more items in this video so that you know what to look for at the beginning of the process. Now, we did just do a video on what happens if you make a mistake on a particular question and how that can ultimately end up denying the entire perm. But what happens if you forget to fill something out? Let's say you don't, answer question 8A. Unfortunately, the employer's failure to complete sections of the 9089, which is the form for the perm, is a violation of the regulations, and the entire case could be denied. And believe it or not, it may seem so small to you. So, for example, there was a case where the employer failed to complete the number of hours that the beneficiary worked in the prior job. Okay, I mean, that's it. Sounds kind of small compared to everything that needs to be done for an advanced degree perm. But the whole petition was denied because of that. So unlike other petitions and applications where there might be some leeway, it is very strict, definitely, with the perm. So errors of omission can be fatal to the application. Now, the employer, attorney, beneficiary must sign the ETA 9089 after certification. So if the ETA 9089 is certified electronically, and what I mean by that is the Department of Labor has signed off on it basically and said, yes, you have sufficiently proven there are no available U.S. workers for the position, then in order for the whole application perm process to be completed and valid, everybody needs to sign it. So make sure that that is done. Now, if the attorney or employer change address, the Department of Labor must be notified. Now, if the application's by mail, which, in reality these days it shouldn't be, the only reason it would be is if the employer tried to log on and make an electronic account with the Department of Labor, and they didn't answer the email, they didn't get the pen, and so forth, and they were precluded from filing electronically. It will be done by mail, but that is such a much more lengthy process that you'll want to make sure your employer does everything possible to get that account open. Again, you can't have the attorney do it. It's the law that the attorney can't open the account for the employer, and they do this to make sure that the employer is real, that they exist, and that the person who is making it can receive emails. After it's made, then a sub-account can be created for the attorney, but not until then. Now, the application needs to be made under penalty of perjury, which means that the employer has to attest or state under the penalty of perjury that the prevailing wage will be paid, and that the position is not vacant to a labor dispute, and that there are sufficient wages to pay the beneficiary. Now, keep in mind that if any of those do turn out to be violated, the employer could be in serious trouble. So if they say they're going to pay the beneficiary $65,422 a year, and they only pay $50,000, that is a clear violation of the immigration laws, and there could be significant consequences after. Now, with the filing of the ETA, of the 9089, no supporting documents are filed. If an audit occurs, then the supporting documents can be submitted, but they have to make a file, they have to keep the supporting documents, and they have to have it just in case it's asked for at the appropriate time. Okay, more on the coming videos.